There are two types of Social Security benefits. The first is Social Security disability, and the second is supplemental benefits, SSI. Social Security disability is an insurance program. It's a disability program that's based on the payment of your FICA taxes of 20 out of the last 40 quarters prior to filing an application. Now, the number of quarters vary based on your age, but for the most part, it's 20 out of 40 quarters. That means that you're insured, but you need to understand that the insured status will end, and it will generally end about 5 years after you last work and your contributions cease. So it's really important that we are timely filing for Social Security disability. As you'll hear, as I explain later, it's going to take a year and a half to 2 years to get through the claims process. And if for some reason you're able to go back to work, that's great. But if you lose your insured status in this standpoint, you'll have to prove that you're disabled from the day you claimed your disability benefits, and then the day you lose your insured status. So we'll talk about that more if anybody has any questions. That's why it's important that you timely file a Social Security disability application. Now, SSDI will pay benefits from the 6th month of disability or 12 months before the application, whichever is later in time. SSDI is going to be paid based on your earnings history. And it'll pay a maximum of $3,627 per month. Social Security uses what's called ACE, average current earnings, and we'll look at your 5 highest years' earnings to determine the amount of your benefits. There are no increases, if you will, except for COLA increases. So whatever your SSDI benefits are based on your earnings record is basically what it's going to be. Now, you also become eligible for Medicare after 29 months of disability. So the first 5 months, you don't get any benefits, even though you may be found to be disabled. That's true for everybody. And then you have to be on Social Security disability for 24 months before you became eligible for Medicare. So that's where we get the 29 months. Now, SSI is available to anybody who's legally in the United States, but it's an asset-based test. So you can only have $2,000 if you're single, or $3,000 if you're married in assets. Cars and house are not included. You get instant Medicaid, and the monthly payment is capped at $914 per month. And you can have to maintain your assets within these asset levels, or you can lose your eligibility for SSI. So now we've set the parameter for SSDI, SSI. And before I move on, most doctors understand that SSDI is something that you've worked for, you've contributed to. There are some doctors who think that SSDI is welfare, and they don't want to support welfare queens or kings. I try to educate physicians about their misconception about that and say, look at your own pay stub. You'll see where you have these FICA withholdings. And doctor, I'm sure you don't think that you're a welfare king or queen if you were to apply for benefits because you've been contributing to this system. So what's the 5-step sequential evaluation? We have to start out with the definition of disability. And just because your doctor says you're disabled or you think you're disabled doesn't mean that you meet the Social Security standard for disability. It's a term of art. It's defined as the inability to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, or which can last or can be expected to last for at least a continuous period of not less than 12 months. So there's a lot of words in this definition, and we're going to break some of these down so that you understand how this definition is actually applied in practice. Now, on this screen, you can see the 5-step sequential evaluation, and it is just that, sequential. If you don't meet step 1, you're denied. If you don't meet step 2, you're denied. If you don't meet step 3, you're not denied, but we go on to steps 4 and 5. If you don't meet step 4, you're denied, depending on your age. And if step 5, if you don't meet that test, you're denied. So we have to go through every one of these steps, but at any one of these steps, with the exception of 3, you can be kicked out. So I'm going to break this down in layman's terms. The 5-step sequential evaluation basically says, are you working? 2, is your medical condition severe? 3, does your medical condition meet what's called a listing? Number 4, can you do the lightest and simplest job you held in the last 15 years? And 5, can you do any other type of work in the mythical, hypothetical, not real world of work that you wouldn't want to do and doesn't pay a living wage in view of your age, your education, the skills that you have learned in your past work, and your functional abilities, your restrictions and limitations. Now, let's talk about step 1. Are you working? So the question becomes, does your medical condition prevent you from performing substantial gainful work on a full-time basis, earning less than $14.70 per month? So you can work, but if you earn $14.71, you're not eligible for benefits because you have exceeded the what's called the SGA. Now, I have clients that bouncing back and forth above that level. I don't like that. I think it makes it more difficult to win a case. I prefer that my clients really keep it well below the 1470 because the judge will say, well, you're $100 close, you're 1370. Why can't you work a couple more hours or a couple more shifts to get over 1470? And if you bite on that and say, well, I could do that, the judge is going to rule against you. So if you're going to work, please keep it under 1470. Number 2, is your medical condition severe? Now, this is designed to weed out cases where there's only minor limitations on your ability to work or where your medical condition won't significantly limit the ability to perform basic work activity for at least 12 months. So that 12-month period is an important consideration. Sometimes Social Security will say, well, we think you're going to get better in 12 months, so we're not going to deny your claim. And that can be a hurdle for people who have slow progressing medical conditions or which vary in intensity and frequency. Number 3, I'm going to take us back to biology. When we studied biology, we learned biology in terms of body systems, and the Social Security Administration takes a systems-based approach to the analysis of a claim. There's a book called the Blue Book or the Listing of Impairments, and we can open up various sections to see whether or not potentially the medical condition qualifies as a listed condition, and if so, whether or not people meet the listing. Now, medical records have to document the elements of the listing or the medical equivalent of a listing. But as I tell my clients, doctors didn't go to medical school to write a report that meets every element of a listing if your medical condition has a listing. So the majority of the time, while I try to develop an impairment at the listing level, the reality is these cases are decided at steps 4 and 5 of the 5-step sequential evaluation. Now, as I said, you have to meet every element. And if you meet every element at step 3, your benefits are automatically awarded. And if you don't, then we go on to address how your symptoms impact your ability to function. My clients love 2 words. I have them drilled in their heads: symptoms and functionality. Now, I think that is it really crucial that you ultimately get a form filled out by your physicians called residual functional capacity forms. If your medical records don't address, and most don't, your level of functioning, Social Security will do one of 2 things. They will have a consulting physician review your medical records. And you can imagine that they're being paid by Social Security, and they're not necessarily inclined to say that you are unable to do sedentary work and generally say that you're able to do light work. Most of these doctors haven't been practicing in a million years, but that doesn't mean that Social Security won't recognize their opinion. So I always want my client's physician to complete a residual functional capacity form. Now, these forms were developed by lawyers generally, but Dr. Trevino's great PA has developed a POTS residual functional capacity form. And I think it's fantastic. And we have adapted it and we use it in our practice. By the way, I have a nationwide practice for both Social Security and ERISA disability benefits. And we use that POTS form regardless of where our clients live and regardless of whether or not it's a Social Security case or an ERISA disability case. Now, what's important about this form is that Social Security is going to compare your restrictions and limitations to the functional requirements of the lightest job you did in the 15 years before you became disabled, both physically, cognitively, and emotionally. And so at step 4, and I think at step 5, the key is to have this residual functional capacity form. There are many times I use more than one. It's not unusual for my clients to be depressed, have panic attacks. So I am going to ask them, if they're seeing a psychologist, psychiatrist, or mental health person, to get a psychiatric residual functional capacity form completed in addition to a POTS form or whatever applicable form that we can use. And as I said, many times we'll use more than one, because I never argue that there's just one disabling condition. I argue each condition individually and then collectively, because after all, you're a whole person. And I want the Social Security Administration not to parse your claim in terms of specific disabilities, but to see you as a total individual and consider the whole spectrum of disabling conditions. So, as I said, the key really is step 5. Can you do other work in the national economy, mythical, not real world, hypothetical, in view of your age, education, work experience, and your capabilities? I'm going to give you a little shorthand key to winning so that you understand what it is you need to prove. Now, generally, if you're under age 50, you have to be unable to perform sedentary work. And as I explain to my clients, it's the ability to lift maximum of 10 pounds, sit 6, occasionally walk and stand 2 hours out of an 8-hour day. Now, I'm sure you all say, well, I can't even do sedentary work. It's very hard to get the Social Security Administration to buy that, particularly if we have a younger individual. But there are ways that we can get around this particular bias in sedentary work. Many times, Social Security, the judges will say that you can do light work, and I'm going to use a technical term. We have to erode that ability to do light work so that basically we destroy the ability to do it on a full-time sustained basis. Now, if you're under age 50, I have to tell you, and particularly if you're in your 20s or 30s, there is a significant bias that Social Security has against younger individuals. They think that because a person is young, they can be retrained, they can go to school, they can learn simple routine tasks and work at a job like McDonald's. These cases are winnable. I just won a case 2 weeks ago involving a 23-year-old woman who had POTS. So each case obviously is unique. And when I get a case where I have someone under 50, I'm very well aware of that bias, and I'm working hard to help overcome that bias in our RFC forms and our medical records, the forms that you fill out, and your preparation at trial. Now, if we go to a hearing, you need to understand that first, the judge is not bound by any earlier denial. So the judge gets to exercise their own independent judgment. Most of the time, there are just 2 witnesses, you and the vocational evaluator. And with all due respect, they don't want to hear from your mother, father, brother, sister, best friend. They're not interested in any of that because they think those people are biased. Now, that isn't to say in the right case, I don't use them, but it's going to be you and the vocational evaluator. There might be a medical claims examiner or a medical examiner who will be asked to testify. Now, at the hearing stage, which is about 45 minutes, the hearing is about 45 minutes, and we do these days by phone or by Zoom. Very rarely are we having in-person hearings. The judge is going to give that vocational evaluator, that other person, a hypothetical after you testify. First 30 minutes you, last 15 minutes the vocational evaluator. And you're not going to understand the language, and it's going to go really, really quickly. but they're going to give a hypothetical about your age, education, skills. And the answers, well, the hypothetical and the answers to that hypothetical will make or break your case. And I'm going to talk about that later, and I'm going to actually give you an example of how this hypothetical works. But that is an overview of the 5-step sequential evaluation.